Hey,
Hi John, how are you?
This is
I'm
the
yeah.
Neoliberal Round
Oh my God,
Podcast.
you give you. I was ecstatic earlier when you sent me that text. I was so happy.
Yeah, I know. Me too. Because originally it was like across the board, but so so there's good news and not so good news, but then it kind of ends on good news again.
Wait, hold
So
on. Wait, hold on. You did send me the text though that you said that the Fifth Circuit withdrew its opinion and granted rehearing. They admitted they were
correct.
wrong.
So that's the good news. So the good news is that when the opinion came out, they completely butchered the approach to the leadership enhancement, which requires them to show definitively that there was one other criminally responsible person. They don't have to. I mean, there is an interpretation suggesting they have to actually name the individual, but
Okay.
even taking the interpretation most favorable to the government, that they don't actually have to identify the person, but just show that there definitely was another person established, even if that person's identity was unknown. They didn't do that. And so that was the most legally indefensible part of the opinion. The other part was how they treated general impeachment evidence, Linda Rivera lying that it's saying she was single, with motive evidence, right? The IRS tax lien showing that she actually had a criminal motivation for lying. And so, and of course, the government could have indicted her, and so that's why she got on the stand and provided the false testimony. Well, they tried to say that that was general impeachment evidence, and it's like, no, motive and bias evidence is totally different, legally recognized category. And so, but they tried to blur the lines because, of course, that would necessitate a new trial. So I addressed that as well. They were supposed to apply what's called the de novo standard of review for obstruction, because they said that my lawsuits against Trump were and IRS agent Tuan Ma constitute obstruction. But that's the rule. The law specifically says exercising a constitutional right can never constitute obstruction of justice.
That's interesting. What does Donald Trump have to do with this lawsuit against you regarding taxation?
Exactly. I mean, well, exactly. Why was that even brought up as an issue? He was a private citizen when those cases were filed. So it makes no sense. So again, thankfully, they came back. They withdrew the opinion, recognizing its the legal deficiencies in it, which, by the way, only happens 1.5% of the time. So this is incredibly rare for them to admit that they were wrong. But they went ahead and substituted a new opinion now, trying to beef up the facts and trying to still affirm the case. So just yesterday, we already submitted a full response again. We're calling for another petition for rehearing, and we're also now asking for the full Fifth Circuit to intervene and to overturn the panel and to issue a correct opinion, because it's clear. Oh, so what they did now is they said, based on the record as a whole, it's plausible that there was at least one other person involved.
And by that, you mean another witness that you were not privy to, that the Fed had made deals with.
Yeah, they're basically saying that somebody else at the firm was responsible for fabricated deductions. And so, again, it's a baseless theory of conspiracy, right? Two or more people, they're saying that somebody else had to have been involved. But it's just like, you guys, the district court never found that. You're inventing that fact. And the court never said, oh, we're applying the leadership enhancement because we believe that there was at least one other person criminally responsible. All the judge said from the stand was, oh, well, if he's not a leader and I've never seen one. And it's just like, what? Like, the argument that we made at sentencing was, you guys haven't shown that there were four other criminally responsible people, let alone one. The government argued for the first time, oh, this was an extensive crime, and so clearly he was the leader of it. But if you're going to make that argument, you still have to show at least one other person was criminally responsible. They never made that finding. The judge never stated that finding. So what this is called, it's called appellate fact finding, which the Supreme Court already said. Appellate courts can't do that. Appellate courts review facts determined by the district court. They don't invent new facts. And what the appellate court is doing here is they're inventing new facts to avoid overturning a clearly indefensible ruling by the judge. And so, and there's not just one, but three Supreme Court cases that it goes against. So again, it's a super, super weak judgment. And not only that, also the whole the Brady violation with Linda Rivera also violates three, including one just last year, a 2025 Supreme Court decision, where the Supreme Court said what the Fifth Circuit is doing right now, treating motive and bias evidence as general impeachment evidence to ignore it. Literally just last year, the Supreme Court said, you cannot do that. And the Fifth Circuit turns around and does it anyways. And it's because, again, like Fifth Circuit's just become a part of this conviction machine, where it's just, they just want to affirm every conviction, regardless of the facts and circumstances. And even when the Supreme Court says, you can't do this anymore, they turn around and do it anyways.
Okay.
And so, yeah, it's really a runaway renegade circuit. They've already made a conclusion, and they're trying to find the law to justify a predetermined conclusion, which is we don't want this guy to get any relief.
Well, so they are admitting that they're wrong, but they're not withdrawing their decision.
Correct. The panel did withdraw the decision, and they issued now a new opinion with more facts, thinking that, okay, well, with these new additional facts, it's going to strengthen the argument. And they created a new rule that, again, differentiating between general impeachment evidence with Linda Rivera and motive and bias, they treat it all the same, even though the Supreme Court said you can't do that. And then on the leadership, they're basically saying, well, as long as it's plausible that there was one other person involved.
How are they able though to admit that they were wrong and issue a new
exactly.
And without asking for this, look like it's a grounds for a retrial. I'm not understanding.
No, I know. I agree 100%. They've already admitted the facts weren't there. So when I called them out on it in the petition, and by the way, I did the petition for rehearing en banc, and then my wife had about 700 emails sent out to professors, nonprofits, the media, everybody, even legal scholars, law review journals that for law schools, and everybody started looking into it. And then, of course, the Fifth Circuit knew, okay, there's too many eyes on this now. We gotta withdraw this opinion and beef it up. But again, the only way they could substantiate it was by inventing new facts and engaging in, again, what's called appellate fact finding, which they're not allowed to do. What an honest, panel would have done is said the district court just didn't do their job, so we got to remand it back down, dot the I's, cross the T's. If you want to try to substantiate this again, and then we'll review it when it's more factually developed. But they don't even want to allow that because they know if it goes back down, it opens up the door to a lot more questions. Witnesses can be called, and it can be very dangerous for the government.
Was it the Fifth Circuit that found you guilty, or was it another?
No, it was the district court in Northern District of Texas.
Okay.
And so they're only supposed to review the facts determined by the district court, but instead they're doing what the judge should have done and finding facts and saying, oh, well, we think that there was at least one other criminally responsible participant. It's just like, okay, that's fine, but you still haven't even established extensiveness. They're so obsessed with one issue, they totally forgot about another and left the opinion that was still vulnerable. So it's at this point they're grasping at straws. And, this is definitely going to necessitate either the full Fifth Circuit en banc, which I'm really hoping that Fifth Circuit Judge Dana Douglas, she was appointed by Biden, and she's a lifelong resident of New Orleans, good Christian woman. I'm really hoping that she steps in and sees this for what it is and forces the Fifth Circuit to the full court to take up the case. And if not, then I'm really hoping on one of the three liberal judges on the Supreme Court to intervene and take up certiorari, because again, they've already shown that their opinion was legally flawed. And mind you, they had they had almost 20 months to put this together. Yeah. And I was going to say 19, but no, it's almost 20 months they had to put this together. It didn't even take me 3 days to completely tear it apart. Be like, no, this is completely indefensible. And then to even recognize that, they withdrew it. So it's it's one of those things like, man.
And if you could restate the opinion of the opinion that they are admitting that is wrong can you restate that?
Yes. So what they originally wrote was that they could impose the leadership enhancement on me without having to find that there was anybody else criminally responsible.
Okay.
And that astonishing. That's like, well, then they're basically saying I was a leader of no one. That one, every single legal scholar I spoke to was literally shocked, like completely flabbergasted that the Fifth Circuit actually published that.
Okay.
And that was the main vulnerability of the opinion. The other one was them saying that proof that Linda Rivera got an immunity deal was exposed to criminal indictment. You know, that was just general impeachment evidence. After just last year, the Supreme Court for the third time had to say, no, that's not how you do it. You can't just disregard something like that. The Fifth Circuit did it anyways.
Yeah.
And again, it just shows you how just far off the wing, the Fifth Circuit has gone. And it's ridiculous. They have absolutely no respect for the rule of law whatsoever. They're going to do whatever they want, however they want. And I think they're accountable to no one. And the sad fact is that they know that they're accountable to no one.
Yeah.
And so they got a lifelong appointment, and politicians in black robes.
And you said that the plan is, if your plan is to even go beyond the Fifth Circuit to the Supreme Court, yes?
Yeah, well, I mean, I'm really hoping that, like I said, Dana Douglas or one, because there's 3 liberals that were appointed by Biden on the Fifth Circuit. I'm hoping that one of them takes up the case and just apply the law. That's all I'm asking. Just apply the law fairly. You can still, if you want to uphold the sentence, you can, just without the sentencing enhancements. But again, it's one of those things where, they're just trying to give the harshest possible punishment, completely ignoring the fact that before trial, they rigged it with those fake stipulations. During trial, they rigged it with a compromised witness. After the trial was over, they tried to rig it by changing the transcript. And one thing after another, they keep trying to grasp at straws, coming up with an excuse, right? Like, oh, well, you said in an email, I agree to that. That's not the standard for waiving your Sixth Amendment right to confrontation. You have to read those in open court or have them waived and admitted into the record. They never did that. And then the part where the judge said, I'm not allowing anything into evidence unless it's admitted at trial, was deleted from the transcript. So I challenge the transcript, and then they say, oh, well, you didn't file a separate notice of appeal. That has never been required. A Rule 10e motion to correct a transcript is literally under the federal rules of appellate procedure. It's an appellate motion in an existing appellate case. How am I going to file a notice of appeal for an appellate motion? That makes absolutely no sense. And so they've just gone completely off the reservation. They don't want to, because they know if I get a copy of the audio of the actual what happened at trial, it's going to reveal everything they deleted.
Yeah.
And they can't allow that. There has not been a valid challenge to the Court Reporter Act since 1976. This was going to be the first case in a generation that was going to show the full weight of the Court Reporter Act and how to hold them accountable for the truth. And they still found it's not even a procedural loophole because it's procedural BS. It doesn't exist. What they're claiming, they're saying we don't have jurisdiction because you didn't file a notice of appeal. And that's not true. It's an appellate motion. It was made to their attention. I can't file a notice of appeal for their own decision. And so it's this circular reasoning that has zero logic, but it has one intended goal. It's affirm this at any cost. So, but I still have faith,
Yes.
that the truth is going to come out on this, no matter what they try to do, no matter how much they try to hide it. God is 100% against them, and I know that, and they're going to see it. The truth is going to come out.
Yeah.
So, yeah, one way or another.
One way or the other, and I was wondering if they were kind of, probably withdrew the decision to delay the next step, because I think when you were also suing Donald Trump for violating Section 3 of the 14th Amendment, there were some delays. They were delaying it because you wanted to take it as far as to the Supreme Court, but the lower courts had made some delays. I'm hoping that this is not what's happening here with them, reversing their decisions and so on, so that they're delaying it so that you don't take it to the next level?
I don't know, but I know right now that they knew that the way that they drafted the opinion definitely increased the odds of Supreme Court intervention. They knew that. And I think that's the only reason they withdrew it, is because they were like, oh no, the Supreme Court definitely get involved in this, and they had to beef it up. And I think they thought they beefed it up, but they didn't realize that they plugged up one hole, and it's like a breaking dam. You know what I mean? Like, you plug one hole and then 5 more leaks come out. So, there's even more vulnerabilities. We already submitted over 120 pages. We resubmitted the petition for panel hearing, petition for rehearing en banc, and petition or motion to publish the decision, because I'm basically calling on the Fifth Circuit of saying, hey, you know what? You can't try to railroad me and then leave this as an unpublished, non-official decision when you have deviated so much from what the established law is, not only in the Fifth Circuit, but in every circuit, and even by the Supreme Court. So if you are going to stand by this opinion, you need to publish it. And then that way it officially goes to the Federal Register and other attorneys can examine it. But see, they know they can't allow that to happen, because everything in this decision goes against what they've said in the past on every single issue. When it comes to the standard of review for obstruction, when it comes to the necessity, to identify another criminally responsible person for the leadership enhancement, when it comes to reading stipulations in open court, when it comes to the difference between bias evidence and general impeachment evidence for the Brady violation, when it comes to their independent authority to review court transcript alterations, every single issue, they completely ignored the law and tried to weasel, a BS, weave it together, a BS decision. It just, again, completely is contrary to all established law.
Yeah. Well, I mean, thank you for sharing. We'll continue to share this case. And I wrote an article when the last time we had this. I wrote an article and published it and generated throughout every single platform that I have access to, so that people get to know what's going on in their country and here in the US. But we're praying that it sounds like you're not giving up, and I hope you don't give up. I hope you continue to fight. And you sound really good. How are you doing there? You holding up well?
Yeah, I'm doing good. I have a peace knowing that, I know God's on my side. Yeah. And I know that in their own minds, they've gotten away with this. Nobody in the public believes them. Every single law review editor I've spoken to that's looked into it has been completely astonished on every single issue. Law professors as well. Most of them are just like, well, this is outside my area of expertise, and it looks like your drafting is doing well. Again, we got the petition for rehearing granted. They withdrew it, of course, only to come back and try to beef it up. But that's a strong signal showing that they had 20 months to put together an opinion, and it only took me 3 days to look at it and completely deconstruct it and show how it was contrary to all established law. And that would have just been me saying it, which people could take that for whatever it's worth. But the fact that they withdrew the opinion, that only happens in 1.5% of cases, shows that they were scared. Like, oh wow, if he could do this in 3 days, then anybody looking at this would know how indefensible this is. So, what we gotta do is keep exposing it.
And keep at it, and I pray that you will continue to be positive, and that your family will continue to do well, and God will protect them and protect you while you are incarcerated from any harm and danger that can come your way. That God will continue to inspire you and grant you favor. Even now, I pray that God will just continue to grant you favor and to inspire you to be able to overcome the challenges of this experience, and that you will also learn and grow and develop. And I just believe that something powerful will come out of this story. I believe it. I sense it. I think something powerful will come from it. And I'm praying that, I pray whatever I can from this side of life to help and to support you, then yes, I will continue to do so with the neoliberal. And but thank you so much, man. By the way, I'm just saying that I still can't record you, yes?
Oh yeah, you can. This is perfectly fine.
Oh, great, great. So I can share this conversation on the podcast.
Absolutely.
Great, great, great. Well, can I say that I'm talking with John Anthony Castro, the former GOP presidential candidate who is a political prisoner, and he is fighting for his freedom despite the odds, despite the challenges. Can I say that?
Absolutely.
Yes, yes, yes.
100% sure.
Well, thank you so much. We're talking with John Anthony Castro, former GOP presidential candidate. He was suing Donald Trump for violating Section 3 of the 14th Amendment, and they upended his campaign because of upended his campaign and everything what he was trying to do because they wanted to curry favor with probably Mr. Donald Trump. But our prayers are with you, sir.
Thank you.
We've
Thank
been
you so much.
we've been tracking you from the very day you announced that you were going to run, and when you were suing the FEC, then you had to sue Donald Trump, and it's been
Yeah.
quite. This is what happened when we take on the establishment, but we have to. We can't back down.
Absolutely.
We cannot back down. Yeah.
Yeah. They have to know they can't get away with it.
They have to know that they can't get away with it. Yes, that is true. Thank you so much, John. Keep in touch.
You're welcome. All right, take care.
Yeah, bye-bye.
God bless.
God bless. We were talking with John Anthony Castro on the phone, and we're praying for him, and we're hoping that his case will turn out another way, that he will get the victory, and but it's quite telling that this country is not built on the powerful. This country got an independence in 1776 from Britain. They took it. Okay, they're not about the monarchical power, and they are about they promote for the people by the people, equal rights and so on. But this young man took on the establishment, and they threw him in prison. But we're showing his story on the podcast and on the YouTube channel, and we're also writing an article. It's available in the Neoliberal Journals. Thank you for watching and for listening. I'm Renaldo McKenzie, your host and creator. Please email us at info@theneoliberal.com, and you can visit us at theneoliberal.com or renaldocmckenzie.com. Follow us on Twitter, Renaldo McKenzie or the Neoliberal Co. Facebook, the Neoliberal or Renaldo McKenzie. Instagram, Renaldo McKenzie. We're also available on Reddit and LinkedIn and the like, TikTok, whatever the case is. Subscribe to our YouTube channel, and please get a copy of my book, Neoliberalism, Globalization, Income Inequality, Poverty and Resistance. Welcome.